In today's video, we're going to talk about consideration, which is the second element when you are examining whether or not a contract is a valid contract. Now, consideration is something that is generally going to be present at the time the agreement is formed. So when the agreement is formed, obviously, as we've already been over in previous videos, the offer and the acceptance both come together, and all of the terms of the contract, all of the rights and duties that the parties are creating and that they're agreeing to take on, those terms are obviously a part of the agreement. And it's in some of those key terms where we find consideration. Again, well, assuming it's a valid contract, we'll find consideration. If we don't find consideration as part of those terms in the initial agreement, then we have potentially a failure to create a binding contract. Now, there is one key exception to the consideration doctrine. I'm not even actually sure if exception is the correct word. I guess it's kind of more of a backup in the event that consideration has failed for whatever reason. That is the doctrine of promissory estoppel, and I may do a separate video on that. But promissory estoppel is a concept that's very, very rarely used. You have to meet very specific, kind of a fairly high threshold to be able to show that. So you don't ever want to rely on that as a backup. You almost want to pretend that it doesn't exist. If your goal is to create a binding agreement, if you want to create a contract, you need to be making sure that consideration is very clear in the terms of the agreement at the time you're entering the agreement. So there's basically kind of the easiest way to define consideration is the exchange of value between the parties. And so we can really kind of break that down into the two main components of both this concept of exchange and then also separately this concept of value. So when we talk about an exchange, what we mean here is that we want to see value being given by both sides. So it's not enough, for example, for me to say, I promise that I will give you $1 million tomorrow, right? Even if I, swear on a stack of Bibles, here I am on video, right? I promise I'm going to do it. Great. That kind of a promise to give a gift in the future is actually not, that cannot create a binding obligation, at least under basic contract law. A promise to give a gift in the future is a promise to give value from one side, right? I may be making the promise to give you something of value. However, we don't have anything being given up that's of any value coming from you, right? There's no exchange that's taking place. We've got value coming from one side, but not the other side. That can't be a contract. Now, as a different example, if I say I promise to give you $10,000 next week in exchange for the purchase of your vehicle, right, your car, then at that point, right, we may have a situation where we're creating a valid contract. We'll see in a little bit that actually is a type of contract that would be required to be in writing of some sort, but that's a separate issue. As far as whether or not we have consideration in that example, we do clearly have consideration as part of the terms of the agreement. So really all that you're doing is just making sure that in our contract terms, we're making it clear what value is being given up and making sure that that value is being exchanged by both parties, right? There's no freebies basically in contract law. Now, another key thing to watch for in consideration is that we want to make sure that the exchange, right, the value that's being given up is taking place as part of the current contract bargain. There have been some cases, and there's a topic here that I'll write. We'll say not sufficient, right? Okay, so not sufficient is what we call past consideration. Okay, make sure you guys can see that. Yeah. Okay, so one example when I'm talking about the importance of making sure that the exchange of value is taking place as part of the current contract bargain, what we have to avoid is something that we call past consideration. So this actually has come up in the employment context quite a few times. It is sort of a key thing to watch out for in some of these situations. There was a real famous case where this lady had worked, I believe she was like a secretary or a housekeeper or something like that. But she had worked very, very closely and done a lot of work for this guy over a period of, I think it was like 40 years. So they had this long standing relationship. She was a valued employee, extremely loyal, had done all this work for, really for her whole career for this one particular employer. And at one point, he said to her, in thank you, right, as a thank you for your many, many, many years of service and for all of your hard work over the years, I want to make sure that you have a very special Christmas bonus this year. And I think he promised to give her something like $10,000. Well, unfortunately, he passed away. And so when his whoever it was appointed to administer his estate, she went to the person who was overseeing his estate and explained that this agreement had been made, explained that, he had promised her this $10,000 bonus, and it was something that, she had really been, expecting to get. And whoever was running the estate refused to honor that promise. Now, the key thing to recognize is if we did have a situation where a valid contract was created, the estate would have been legally obligated to honor the promise. So if I enter into a contract to sell my car to somebody and then I pass away, whoever it is that's overseeing my estate is going to be obligated to honor that contract to sell the car. So because the car is really no longer considered to be part of my property, I've made a commitment, right, to sell it to somebody else. So that would have had to be honored. However, in this case, because it did go to court, she sued to enforce what she was arguing was a valid contract. The court ruled against her, ruled in favor of the administrator of the estate, and found that there was no current consideration as part of any kind of exchange of value in creating a contract in current terms. Now, of course, the employer had promised to give $10,000. There's value coming from that side. The problem was that what he was saying was he was giving the money as a thank you for previous work that had already been done. And that previous work is what we call past consideration. And really, it can't serve as consideration at all for a new and existing type of a contract. It's something that has already taken place. That work was not done in exchange for the $10,000, right? It was done simply as part of her previous obligations just as an employee. So past consideration along those lines cannot serve as consideration for a new contract that you're entering into. So that's definitely something to watch out for. There's actually a few employment kind of contexts where some of these consideration problems come up, and so I'll mention one more, I think, before we quit today. All right, so that's the idea of exchange. Now, the other question here is value. So what do we mean when we say value? I guess the most important thing to mention to begin with is our little note here. One thing we don't actually care about is what it is that's being promised or how much is being promised. That is not an issue in terms of consideration. If I decide, for example, that I want to sell you my if I have a Picasso painting that's worth millions and millions of dollars, and I agree to sell it to you for $5, that is not a consideration problem. The court is not going to take a look at that agreement and say, well, but obviously the Picasso painting was worth a whole lot more than $5. So if I try to get out of it later on, get out of that sale and say, oh, well, there's no consideration here because, right, the purchase price was only $5 and that's not a fair price or that's not enough money to pay. The court's going to say, look, that's not something that we're concerned about in terms of consideration. As far as making the decision of what is the appropriate amount of money to accept, how much are you willing to sell an item for, how much are you willing to pay for a good or a service. The whole principle of freedom of contract, which is really just so fundamental to the common law legal system, and certainly to the contract law in the United States. Freedom of contract is just absolutely a central principle. What that says is we let the parties make the decisions for themselves in terms of what bargain are they willing to make, right? How much are they willing to pay for a good or a service? How much are they willing to sell a good or a service for? If you think, for example, let's say that, let me see, do I have anything good here that I can, let me see if there's anything good that I've got around me that I can sell right now. I've got my cup, but we've already done that one as an example. That one's not so much fun. Let's see here. Okay, here we go. All right. So here we've got this lovely little volume here, How to Talk So Little Kids Will Listen, right? If I make an offer to sell this book if I throw it out there to the entire class and I say, hey, if anybody's willing, just raise your hand, let me know, right? I'm willing to sell this book for $5. Let me put it this way. If you don't actually have a child, right? If you don't have a child who's of toddler age, you might not be willing to make this purchase at all, okay? Maybe you're somebody who has a friend with a toddler that you think could benefit from this book. Maybe you'd be willing to buy the book for $2, but you're not willing to pay $5, so you're not going to raise your hand. If you're like me and you have a 2-year-old who is just who's beginning to show that independence and has learned very clearly how to say the word no, and has learned fairly clearly about things like tantrums and kicking feet on the ground and having your face turn all red when you're upset because mommy and daddy say no, you might be willing to pay $10, $20, right? Even $30 for this book here. So when I say $5, I'm willing to sell it, your hand might shoot up in the air and you might be so excited and you might be thinking you're getting an absolutely wonderful bargain, right? But what that tells us is that, again, right, it's the parties may have various reasons, right? We may each individually have 10,000 reasons for choosing to enter a contract or choosing not to. The courts are not going, because we're recognizing that, the courts are not going to sit there and police, right, is $5 an adequate price or not. If it was good for the parties, it's good for the court. So we're not so much concerned with how much money is given or how much value is given as we are with making sure, okay, we've got a situation where I'm promising to give the book, you're promising in exchange to pay your $5. Now, as another kind of an example, let's say that I am willing to say that if the entire class, if everybody in the class pays me $1 each, I would be willing to come in and teach the rest of this class. So all my future videos, I will wear my penguin Snuggie, which yes, indeed I do have, and I will prove that in the next video. But I have a real nice, cozy, warm, fleecy Snuggie. It's light blue, and it's got these big, goofy-looking penguins all over it. All right. If we were to reach that agreement, is that a situation where we would say that is a contract, right? That is supported by consideration, and therefore it's something that we could call legally valid? The answer, and again, this kind of takes us into our definition of value here. The answer is yes, right? Now, again, in terms of trying to determine, how much is that worth, there may be people in the class who say, I would not pay $1 to see that. As a matter of fact, I would pay you to not wear the penguin Snuggie because that would be weird, right? Somebody might think, you know what, that's so hilarious. I'd be willing to pay $5 or I'd be willing to pay $10. Again, so the question is not, right, even is it something that we can put a specific, market value on? Is it a good deal or not? Courts are not going to get into that question. What we're going to do is say that we've got an exchange from both sides. Another important thing that tells us about the nature of value is that really when we say something has sufficient value for consideration purposes, We're really just saying that I am taking on a new duty or I'm giving up a right that I otherwise would have had. So in this example, right, if I'm agreeing to do something new, right, I'm agreeing to put this Snuggie on and teach the entire rest of the semester wearing the Goofy Snuggie. Clearly, right now, I don't have any obligation to do that. If I enter into that contract, now I have an obligation to do that for the rest of the semester. So taking on that new duty is enough. That's all we're looking at in terms of determining whether or not there's being value exchanged from both sides. Okay, I'm going to quit this video here now that we've actually just kind of gone over the basics. And then I think we'll do a real short video following this. There's a couple key consideration cases I want to talk about, kind of along the lines of saying, talking about past consideration as kind of a common pitfall to watch out for to make sure that you're not running into this problem. There's a couple other issues that can crop up with consideration. Again, like I said, another one of them is employment related. And so I think some case illustrations would be helpful with that, but we'll do that in kind of a separate video and call this one good here.